Mr. Mellor.
Yes.
What I'm going to do now is go through about 4 or 5 documents which take the story through 1989 until your departure from the Department of Health. This is the story about the Mcfarland Trust. I'll go through those documents so that everybody here is aware of them and has seen them. And then at the end of that, I'll ask you some questions about them, so there will be an opportunity for you to comment on them. But at first, and for reasons of time, we'll just go through the documents. If we could begin, please, with WITN 706-8005. If it helps, Mr. Mellor, it's at 3.19 of your statement. This is a minute sent from Mr. Arthur to Mr. Davey of your private office, and also to Mr. Canavan. It states this. Minister of State for Health asked for 2 monthly updates of the Mcfarland Trust, and I enclose the first of their reports. It details the Trust's activities and states that the total of grants made to mid-January 1989 is approximately £600,000. At present, they are maintaining their conservative grant allocation policy, see Appendix 1, but the report indicates they are considering acting as insurers and or mortgagers. This expansion would rapidly consume the £10 million grant. Officials would be happy to meet informally with the Trust's administrator to determine what programme of help they envisage if the Minister of State for Health considers this appropriate. The second report was sent a week later, on the 17th of March 1989, covering the period of the Trust's activities to the 14th of March 1989. I won't bring that up, but the reference for the covering minute is DHSC 303308_007. And in that covering minute, a chaser is sent asking for a response about the proposed informal meeting. If we now go, please, to DHSC 303319_012, this is the covering minute for the third of the 2 monthly reports. Sent again from Mr. Arthur, again to Mr. Canavan and Mr. Davey. It's dated the 21st of July 1989, so some months have passed. The report covered the period to the 31st of May.
Yes, Mr. Davey then replaced. Mr. Davey is one of my great successes in life, you know, because he came to my private office as my private secretary, and I used to play loud classical music to console me. He got so into it, he is now the controller of Radio 3.
In this minute in his previous life, Mr. Davey was informed that when the last summary was submitted in March, it was suggested that an informal meeting between the Department of Health officials and the Trust's administrators might be helpful. The Minister of State for Health subsequently asked the thinking behind this suggestion. There is then the explanation given about the comment in the press about the overly cautious approach, and the officials considered that an informal meeting might elicit more information about future spending plans, particularly with respect to proposed help with mortgages. The Trust's third report shows that their grant allocation policy has resulted in a total of £1.4 million being paid out by the 31st of May 1989. This was achieved in line with their existing policy of protecting the £10 million capital sum and making payments from the accrued interest. However, the Trust have now sought a meeting with the Department via a letter of the 25th of June to Mr. Heppel, that's Strawn Heppel.
Yeah.
In this, they indicate that they are venturing into the expensive business of helping with housing needs. Thereafter, they envisage that the £10 million may not be adequate to meet all the Trust deed expects of them. They clearly wish to raise this issue and to seek reassurances that, quote, the policies, schemes and practices adopted by the trustees subscribe to the original objectives envisaged by the government in setting up the fund. The ongoing litigation of a High Court recompensation for HIV-infected haemophiliacs and the allied claim by the Haemophilia Society for a £200 million out-of-court settlement is expected to revive media interest in the Mcfarland Trust's activities. A meeting has therefore been arranged for the 7th of September. If we then move on to a report of that meeting, and this is at DHSC 303511_067. I should say this is a document that is not referred to in your witness statement, but that is because the document was only found and provided to you by the inquiry after you had completed your statement.
Mm-hmm.
This is from Strawn Heppel to Mr. Davey again, 14th of September 1989. Minister will wish to know the outcome of my recent meeting with the chairman and representatives of the Mcfarland Trust. The Trust gave an account of their spending which totaled £1 million in 1988 to 1989 and is expected to be just over £1.75 million for the current financial year. I gave them the assurance they were seeking that ministers supported the Trust in its work and were generally content with the progress that had been made so far. As expected, though, the main question they wished to discuss was whether there would be any more government money for the Trust. Payments are already eating into the capital, and the trustees estimate that the original £10 million grant will run out in 7 or 8 years' time. They foresee a continuing need, particularly in supporting dependents and helping with housing costs, and are concerned that they should be able to make commitments with a clearer view of the future of the Trust. The advice I gave them was that the right time to approach ministers about additional funding would be when the Trust funds were sufficient to meet commitments for only another 2 to 3 years. An approach now would be too early for the issue to be properly addressed. I went on to emphasise, though, that we would not wish the trustees to make more frugal offers of help than they would otherwise consider reasonable, simply to conserve funds. The trustees are anxious to have a more formal response which they could use publicly. Some haemophiliacs who do not need help at present ask if the Trust will still be around in a few years' time. I could see the force of this argument. I therefore said that I would consider whether officials could helpfully exchange letters with the Trust which responded to the trustees' concern. Having reflected on this, I think this is the right course, and I propose, if Minister is content, to write on the lines of the attached draft. The contents would be shown to the Trust before the formal exchange, so they would know what to expect. They would show us a copy of their reply in the same way. The draft letter reflects what Mr. Newton said when making the announcement about the Trust of the House, and a copy is attached. I won't take you to that draft. It is to be found at the same reference number, and it reflects what Mr. Heppel said in that minute. Then if we could have DHSC 303511_066. This is your response to Mr. Heppel's minute. It's dated the 22nd of September 1989, and it's sent by your private secretary, who said, "The Minister of State has seen your submission of the 14th of September and is content for you to send the draft at A." He commented, quotes, "I think the draft is excellent. I am personally most sympathetic to the idea of increasing the fund in due course."
Yeah.
Then finally, in this section, if we could look at DHSC 302536_079. If we could look, first of all, at page 1. Now, this is a document that we are going to come back to in a short time, and I won't go through all of it, but it is a briefing that was provided to you on the 26th of October 1989.
Now, that's the one I didn't read.
That's right, but it's the day before your departure from the Department of
Yes.
Health. The reason that I'm doing it, if we could go to page 3.
I mean, I don't mind reading. I just need you to know I haven't prepared this one.
Yes. The reason is really because at page 3, we have a very helpful summary of the position of the Trust as it stood on literally the day before you left the Department of Health. And we can see that it takes the story a little bit further forward from those documents that we have just looked at. What the briefing says is this, and I quote, "From the outset, ministers have made it clear that the £10 million given to the Mcfarland Trust was not intended as a compensation payment to HIV-infected haemophiliacs generally, but was to help in cases of genuine financial need. The Trust's allocation policy is set out in Annex A. Recently, they have extended into the mortgage field in a limited way. Initially, at least the total amount available will be relatively small, up to £1 million, and help will be in the form of an interest-free loan towards part of a house purchase cost in return for an equity share. Outlays from the fund are now running at nearly £2 million per annum. In allocating funds, the trustees do interpret need in a broad way, and officials have encouraged them in this view. As the Minister of Health already knows, there has been recent discussions of this issue, which we propose should result in an exchange of letters between officials and the Trust. Our letter would confirm our understanding that the trustees would not make more limited offers of help than they would otherwise consider reasonable, simply to conserve funds. The letter will also advise the Trust that the right time to approach ministers for additional funding would be when funds were sufficient to meet commitments for only another 2 or 3 years. The proposed reply from the Trust warmly welcomes these reassurances, and the formal exchange will take place shortly. The Minister of Minister of State for Health may wish to note these developments and consider whether to publicise this via a press release. Now, as I've said, you left the department the following day, and the following month, the Mcfarland Trust received an additional £20 million.
Yes, so actually what I wanted done was done by my successor. Not always the case, by the way. So
well, we will come on to that with a different series of questions in due course about the HIV litigation. But looking at the totality of these documents and trying to summarise them and bring them together, it seems that on the 10th of March 1989, the issue of the Mcfarland Trust acting as an insurer or mortgager was raised and a meeting was suggested. That meeting didn't take place until September, some 7 months later. That meeting suggested raising the issue of funding closer to the point when the fund was exhausted, but also suggested an exchange of letters to try to give some degree of reassurance to the Trust. And in the meantime, it appears that some tentative steps were taken by the Trust to provide support for housing. Is that a fair summary, do you think?
Yeah, I think so.
Two issues arising from that. The first is the length of time that it took to get that meeting, 7 months. In your view, was that expected, usual?
Well, it wasn't much. I don't know. I'm not here to comment on the people who've created the diaries, but since the whole argument was that this matter could only be brought to a head when the fund was nearer to being exhausted, I'm not sure much was lost for that. But if this is where we get to the weeds, and I'm not the man to take you into the weeds, I don't think.
On a more general level, does that exchange of correspondence reflect that there was a degree of difficulty that the trustees faced in not having a firm commitment to further funding from the £10 million?
No, I think the trustees would have known, look, please believe I went as far as I possibly could as a minister in my position to give them all the confidence they needed. And it's a counsel of perfection to suggest it could have been any stronger. And they would have been the subject of various little briefings, informal briefings. And, what happened? They hadn't anything like run out of money. And then they got another, what it was, 20 million. So, if every Whitehall story ended as happily as that, the world would be a better place, perhaps.
So just finishing this section, did you have any concerns at the time that you weren't able to give the Trust more assurance to allow them to do more?
No, because that is a constitutional point. I mean, a minister cannot say, in 5 years' time we'll give you this, unless the Treasury have sanctioned it. There was no reason to think that the Treasury would be remotely interested in sanctioning something that far out. So, and most people who know the way around Whitehall would have known that. But, I think that, there are some things that you do in life and you look back and you think, God, why did I say that? Or how stupid, or whatever. I don't feel embarrassed by any of that exchange, which was designed to show confidence in the trust, designed to give them, what they were told was, spend as you normally would, and at a certain point it will be appropriate, we believe, you'll get some more money. And in fact, they got some more money sooner than I had dared to predict.
I'll leave the Mcfarland Trust there as a separate topic and move to the HIV litigation. First of all, during your time at the Department of Health, this is section 4 of your statement, page 20.
Yeah.
In your statement, you say at paragraph 4.1 that you don't recall being given any formal responsibility for the HIV litigation.
No.
But you weren't perhaps surprised that the matter was raised with you.
No.
Is that fair?
Yes.
The first documentary evidence of the involvement of your private office, and I stress private office rather than you necessarily, comes from the 15th of June 1989, when a briefing which was primarily sent to Mr. Freeman as Parliamentary Under-Secretary of State was also copied to your office. I won't take you to that. I'd note for the record the reference is DHSC 304776_039. What I will take you to is a submission that was addressed to you, which was based on the earlier submission to Mr. Freeman, but slightly updated in light of events in the week and a half that have followed. This is a document dated the 26th of June 1989. We could have it on screen, please. It's MHR...
That's 413, right?
413 of your statement, page 23. And the document is MHRA 0017681. And the document is prepared by Mr. Dobson. Now, this is a document that was raised with both Dr. Raymond and Dr. Pickles in their evidence last week, so I don't intend to go through all of it, but I will highlight certain sections. We can see at the start, it says, the purpose of this submission is to inform ministers of the legal action being taken on behalf of a number of haemophiliacs who have been infected with the AIDS virus through blood products and a smaller number of people infected by blood transfusion. And 2, to seek ministers' views on the case for resisting the plaintiff's attempts to proceed by way of a group action. So that is the principal purpose. And then if we go over to the next page, please. We then have 3, to seek ministers' views on the question of ultimate liability raised by counsel for the department. Council seeks advice on whether the regional health authorities' resources will be increased by ministers should cases be lost. And 4, to seek ministers' views on other options for handling the litigation and the controversy which it is likely to engender. I should say, for the record, that although this is a briefing that is drawing your attention to this matter, there had been previous briefings to previous ministers that we will look at in due course. If we could turn, please, to page 3. As I say, I'm not going to go through all of this document because it is one that the inquiry has considered before, but at the bottom of paragraph 5, the final sentence is this. This is in the background about the litigation. We believe that the government has a fair chance of successfully defending its role in the court actions, given that at every stage it has acted as swiftly as possible to minimise the risk of infecting haemophiliacs with AIDS in the light of the best expert opinion available at the time. So that is what is written there for you. Were you aware, or do you think it's likely that you would have been aware, of what research had been done by Department of Health officials before they came to that conclusion?
Do I comment on that in my statement?
No, you don't.
No. So give me that question again, then.
Were you aware, or do you think it's likely that you would have been aware, of the research that had been done by the Department of Health officials before coming to that conclusion?
Probably not. Yeah, that, again, is just the basis that I am not... I mean, I don't feel very defensive about this because we have very good officials and their job was to deal with it if there was anyone any doubt about it. But there's a limit to how much time you could spend riding shotgun on other very gifted people, a lot of them probably a lot more gifted than ministers. So I was quite happy with that. And also, I mean, it was what it was, but I don't think anyone has ever seriously suggested that what we found out was wrong, that everyone is deeply regretting that it wasn't found out at the time when other decisions were taken, you know. I mean, this was a period when people really were trying hard to understand a new phenomenon, namely that blood products designed to save lives could actually cost lives. An awful business.
If we just go back to what was written in this minute to you, you say that you had good officials who were dealing with this matter. Is there a risk, even with the best intentions in the world, of people marking their own homework, in the sense that the same officials providing this advice would have been involved in the decision-making process that was at issue?
You'll have to ask one of them, I think. You've had them, haven't you? You could have.
We've had some of them.
Those that, alas, are still around.
As a minister,
the winnowing fan has taken a number of them away, I know.
As a minister, were you concerned about the possibility that these were officials who were commenting on their own actions?
No, not at all. But then, as I've already said to you, I didn't really have anything much to do with that bit. The consequences of the discovery that these infected blood products had caused the mischief that they had caused over here, I was aware of. But how that came about, whether that could or should have been stopped, was not something that, I really had anything to do with. But I bitterly regret it. And somewhere at the back of my mind, I would like to think that, there might have been ways of anticipating that these blood products bought commercially, often bought, therefore, from impoverished sections of the community in America, I would have felt deeply sceptical about them myself, but that was before my time and not my role.
If I can take you to something that you were asked to decide on this, and it's paragraph 11, page 5 of the document.
Yes. And do I refer to that in my statement?
You do. I will come to the question in a second. It is, I think, paragraph 4.13. This is about the duty of care point. There are some further documents which I will show you about this issue in due course. This is really just to tee those documents up so that we can see the question that you're being asked.
4.15 in mine.
Sorry, 4.15. 4.13 is the introduction to the initial briefing, and then 4.15 concerns paragraphs 10 and 11. And in fact, you quote paragraph 11 there. I'll read it from the document, page 24 of your statement of the House. Council has indicated that he will wish to establish that, in respect of the choice of patient treatment, the duty of care lay with the health authorities and not with the department.
Yes, that was not an argument I appreciated at all.
We will come on to that in a second. This is just so that everybody is aware of what you were being asked. He recognises that there could be presentational difficulties in this. It would be important not to imply that the department had no role in, for example, disseminating expert guidance. But he regards it as necessary to establish this principle, both as a precedent for future litigation and for tactical reasons, so that he can argue that proceedings against the department should be withdrawn. Are ministers content with this approach? The role of the licensing authority and the Committee for the Safety of Medicines raises different issues, and the MCA will be putting up a separate submission on this. Before we turn to your response on that, do you find it unusual that you would be asked for a minister's view on this point of law, or is that something that you would expect?
No, I wouldn't be asked. I'm not being asked for my view on the merits of the point of law. I'm being asked whether I can cope with the presentational consequences of that argument being run.
And you're approaching that question as a minister rather than as the lawyer you once were.
But I mean, that's what ministers have to decide. If somebody stands up in court and on behalf of the department says something, a minister cannot be heard to say, well, that's what they took that decision. Ministers are expected to know. I mean, if ministers have any relevance to any of this, It is to actually handle public confidence. And I was very acutely conscious that on this particular matter, public confidence hung by a thread.
As I say, we'll come on to your response on that point. But before we do, I'm just going to look at paragraph 12 of the same submission. This is at 4.1.
I mean, it's up to you, obviously, how you work it. I'd almost rather, unless it was really unhelpful, to deal with the point in 4.11 and then get on to what is a related but different point about the schemes for no-fault compensation. I do regard those as two different issues.
I'm happy to do so. Let's do it that way.
Would you mind? I'm sorry.
No, not at all. Not at all.
Yeah, thank you.
DHSC 303989_071.
Yeah.
This is your response to the submission of the 26th of June sent from your private office. If it helps, it's at 4.23 of your written statement. It's dated the 24th of July 1989, and it says this: Minister of State has seen the submission of the 26th of June and has commented. For the present, I agree with the line proposed at paragraph 9. That's about class actions and lead cases. We needn't trouble you with that. Then I am cautious about the line at paragraph 11. I believe that the health authorities act under our guidance in such matters. Equally, though, I do not favour offering any indemnity at this stage. Now, leaving aside the indemnity point, which is about whether or not the Department of Health will provide an indemnity for the health authorities, the line at paragraph 11 is the one that we have just looked at about running the duty of care point. To ask an open question, why were you cautious about running?
Well, because I just think it's shoddy, or appears shoddy, to say, oh, we didn't have a duty of care. Yeah, some poor devil has got HIV, and oh, we didn't have a duty of care. I just couldn't mouth the words, personally. I mean, lawyers are paid to mouth those sort of words, but I'm not prepared to take responsibility for that. And in fact, as you go on down, the infection of haemophiliacs with the AIDS virus, as I say in the fourth point of it, is a great tragedy, one of the worst medical tragedies of recent times. And then my private secretary, in the longer term, Mr. Mellor has said he's not convinced that this approach will be adequate. I mean, it's the Pontius Pilate defense, isn't it? Bring me a bowl, I'll wash my hands of this stuff. Well, not me.
When you say in the minute that you believe that the health authorities act under our guidance in such matters, what did you mean by that?
Well, because
phrase?
they're part of the structure. A health authority is part of the health service structure. It's always been one of the things that's bedeviled the NHS as to whether it's run by officials who have, job titles based on the NHS, or whether it's run by ministers. Hopefully greater clarity has been brought to bear on that over the years, but as things stood in those days, some poor kid was badly treated by the NHS and it becomes the minister's personal fault or responsibility, a ludicrous way for these things to be done. But I was very conscious of the fact that mishandling this matter would be a very serious blow to people's confidence. And I never believed for a single solitary moment that we would be able to resist the claims that were being made, and I had no stomach for the fight.
Should we understand then that your comments here and the comments that you've just read out at point 4 and then in the concluding paragraph, these aren't narrow legalistic points about technicalities of law? These are
No, I don't want there to be any narrow legalistic points. Lawyers, and I was one, I can't deny it. I used to tell my mother that I played the piano in a brothel, but she wouldn't believe me. She knew I was a lawyer. But basically, the fact of the matter is that narrow legalistic points are no good in a situation like this. And indeed, as we discovered when, was it Harrod, Mr. Justice...
Ognall. Ognall.
Ognall. I mean, he made it clear he wasn't going to have any truck with that, and well done him, I mean, there are certain matters where, for all we have to deal, the currency of the lawyer is technicalities, and at times when it's quite right to give technicalities. I'm not against technicalities. But this was never, ever going to wash, because people were going to feel offended by this whole thing. I felt offended by it. Didn't need anyone else to tell me to be offended. I was offended.
So was it your position that there was a broad political or moral responsibility that rested squarely with the Department of Health?
Of course. Exactly right.
The fourth point...
And it was only 1,200 of them, you see. This is where I then got myself into trouble, because suddenly, I don't even know what diazepam, unfortunately, I've never had, but suddenly all the people who'd had a bit too much diazepam were sort of lining up to take advantage of it. This is the problem with government. You could say, I'm going to make an exception for these 1,200 people, let them have the fat of the land, and then you find a lot of people who took, what was the name of that wretched thing?
Benzodiazepines.
Yeah, but what was the name of the...
Valium.
Valium. People who sort of stoked themselves up on Valium expected to benefit from something that was brought in to deal with someone who'd been given a fatal disease by an infected blood product. And that is the difficulty always, and why Whitehall is often very cautious about this. They try to do the right thing, and then they find all manner of, well, let's be honest, I have no particular interest or sympathy with people who, got themselves hooked on Valium. And I certainly didn't want them to be the beneficiary of me shedding bitter tears over what happened to people who'd got AIDS through, being treated for their blood disorder.
Just so that everybody is aware of the context, there was at the time litigation that was ongoing, or at least in prospect, about benzodiazepines.
Yes, and I even asked if counsel could use that argument in relation to that and forget about it in relation to haemophiliacs, but I was advised that wasn't perhaps such a good idea, but it would have been very tempting.
But it does show, does it not, that the department had broader concerns than those who had been infected by HIV.
Well, that's their job. I was in a happy position that I didn't have to worry about all of that. And no, they were right. Of course they were right. But it just shows, everyone thinks how easy it is to sort these things out. But of course, what you do is you open a gate, and before you know it, all manner of other, I regard as less deserving causes, stream through. And that was what we faced.
Does it perhaps reflect as well that the distinction between the officials in the department and the ministers, in that the officials will bring these matters to your attention, but it is the minister ultimately
who has to decide? Yes. I mean, in the end, wanting to spoil the end of the story, but we did get there. But I mean, proper payments were made, as I'm sure there are people who thought they weren't adequate. It was just like more adequate than it started off as. But it's frustrating. See, what I wanted to do was just to deal straight away with this problem and just offer proper compensation and hope that the misery that we'd inflicted without intending to on these folk at least could be alleviated to some degree. And of course, happily, because of the way that things have panned out, a lot of people have lived a lot longer than was then anticipated. At that time, we thought that AIDS was a death sentence. And fortunately, we were wrong about that, but it's still not very pleasant to have it. I have a very dear friend who got AIDS 40-odd years ago, and in fact, he won't mind me mentioning it, dear Cabinet Minister Labour, he remains a close friend. And, he is still here, very happy, but the ravages of the treatment, it's awful, but at least you're still here,
I'm going to ask very quickly about the points at footnote or line 3 of this document. I would not wish to pursue the West German scheme.
Yes,
but I would welcome a checklist of information.
You're right to do it, yeah.
As to how other countries with this problem have dealt with the matter. Now, the West German scheme, I don't think I need to take you back to the document, but it was a payment scheme that was based on the idea of a no-fault compensation.
And it was £30,000.
Yes.
I mean, a fat lot of good that would do.
Was that your reason for not being in favour of pursuing?
Yes. I mean, if we're going to offer people compensation, it should be proper compensation. And we've never adopted no-fault liability, because no-fault liability, in a way, is the easy way out for those who should have to judge themselves as to what they did. Because no-fault liability means you get money, but they never then go on to ask. A lot of people who might say, I'm in favour of no-fault liability, what do you end up with? You don't end up with enough for the people who really ought to get more.
That is a comment about imposing no-fault liability across the NHS system.
And they've never done that.
I think you say later in your statement, I'm afraid I don't have a reference to hand, but it hasn't been introduced for 30 years, and you say there is good reason for it not being
introduced. Yes, and the good reason is that no-fault liability means the really deserving cases don't get what they should get. I'm not saying all the other people are undeserving, but, there are shades of who is deserving and who isn't. I'm sure I'll be inundated with angry... Twitter will probably be full of people angry at me, not worrying enough about diazepam, but, that's an issue I'll have to cope with in due course. But what did bother me all the way through, because I saw it with my own eyes, is the awfulness of HIV. And to get HIV through a treatment that was supposed to deal with an existing problem, that's awful.
The last thing on this document, we can see you express your view that you're not convinced that the approach is going to be adequate. Yes. You say Mr. Mellor would like a meeting to discuss this in early September. Mr. McHugh will be contacting you to arrange this. Mr. McHugh, I understand, was your diary secretary.
Yeah, probably.
Just so that the chair is aware, neither your legal team nor the inquiry team have been able to find what is a definitive checklist of information for international comparisons that arose from this document, but there are other documents we'll look at.
But I did put something in one of my statement, didn't I? It was in some...
Yes. Later on, when you're Chief Secretary, you are provided with such a table. It's just that we haven't been able to find the particular table that follows on from this minute. Now, you referred to that meeting in September. Again, neither your team nor our team have been able to find minutes of that meeting, but we have found references elsewhere to the fact that some form of meeting did take place. I'll just put those on the record. It's MHRA 0017687 and DHSC 0003315_004. Both refer to a meeting which took place on or around the 30th of August between you, the CMO. I'm afraid we don't know who else was there, but some form of meeting seems to have taken place.
I'm sad about that, because that would have been me wanting to have a sit down with Donald to get his wisdom on this. This was so yes, and I sadly can't remember what happened.
We will continue to look. If we can find any further documents, we will seek to provide them to you. The next series of documents comes from October 1989, so about a month or so after that meeting. And it begins with again with a Sunday Times article. If we could have the reference up on screen, please. DHSC 0046937_132.
And can you give me a reference to my statement there?
Page 29, 4.34.
Yeah.
I won't read through the whole of this article. There are one or two points that I would just like to bring your attention to. If we could go column 1, paragraph 6, towards the bottom, please. Beginning one by one. There is a redaction there, which is the name of somebody who had been affected with HIV. One by one, this person has watched fellow haemophiliacs with AIDS die, leaving their families in hardship. He recognises that even if he wins his case, that is the HIV litigation, he is unlikely to be alive to enjoy the benefits. His lawyers estimate it could take another 18 months for the issue to work its way through the courts. A campaign is now intensifying to save this person and those like him from the added trauma of such a battle. As MPs return from the summer recess, they will find themselves lobbied by the Haemophilia Society, pressing the government to pay substantial out-of-court settlements. If we could go to the next column, please, picking it up from the words Frank Field. Frank Field, the chairman of the Social Services Select Committee and vice president of the Haemophilia Society, will be among those heading the campaign in Parliament. Quotes, "We already know that over 100 people have died. This issue isn't going to go away. The government has a duty to act quickly," he said. "What most of these people want is simply to know that their families will be financially secure when they are gone. Surely that is not too much." If we could then please go to column 3. And forgive me. It's down towards the bottom, the paragraph starting "Owen said." This is a reference to Dr. David Owen, your predecessor. Not predecessor, but one of the previous occupants of a post of Minister of State for Health. And Dr. Owen is quoted as saying, "It is a great scandal. I was absolutely appalled when I discovered so little had been done. I believe there was serious maladministration on the part of the Department of Health." And that is a reference particularly to the failure to achieve self-sufficiency in blood products. And then if we could go to the next column, please. And the final paragraph. The final 2 paragraphs, beginning with a redaction. Sorry, if we could just come out again, please, for a second. I'm sorry, it's the 4th column, the last of the long columns, the final paragraph there. Thank you. And this is, again, another name redacted of a person with haemophilia who had been infected. And it says, "This person is a victim whose plight was first highlighted in the Sunday Times last year and is still waiting for action, more than 2 years after starting legal proceedings. As yet, he has not developed AIDS, but last week he went into hospital for cancer treatment, and he knows that he may never come out. His view of the government's position is uncompromising. Quotes, their attitude seems to be that if they leave it long enough, we will all die off, and there won't be much compensation to pay.
So much compensation.
So much compensation to pay. So far, they have completely failed to show even a moral acceptance of their mistake. I can see them contesting it all the way." And then in the next column, there is a comparison of some of the international other countries and their approach. And if I read from that, in West Germany, where drug companies pay a proportion of their profits into a fund to cover such cases, victims have been paid between £15,000 and £160,000. In Scandinavia, governments have made awards of about £18,000, while in France, state payments are up to £17,000 for a victim and £22,500 for the family of a haemophiliac who has died of AIDS. A couple of points arising from that statement. The political pressure. How significant was that pressure on the Department of Health and on you at that time, October 1989, in thinking about how you were going to approach?
Well, I mean, it's often helpful to have political pressure. I did not personally need it, and I think most of us who worked on this issue, Department of Health, didn't need it. But of course, those who might have needed it, the Treasury and whatever, it was no bad thing. I'm only checking up on this because this was what I think my final act at the department was, to ask for advice on this and what the response would be. And I'm not sure, was this also the one where the chap who was their source, it's a false name, isn't it? Not that makes that much difference, but I don't think he existed.
I don't think that's necessarily this article. I think that there may be another reference.
But anyway, look, the personally, speaking only for myself, I welcomed this kind of article, not because I wanted to be able to be reacting not just to my own predisposition, something had to be done and quickly, but that this was showed the kind of pressure that was building up, and it was the job of ministers to respond to these public confidence issues. There was no constituency out there for being difficult with people who were going through what these poor people were going through.
So did it help you as a health minister to take this matter to your cabinet and treasury colleagues?
It certainly would have done, yes.
David Owen's quotation from that article about maladministration, was that something that was brought to your attention either by this article or by other things that David Owen had said?
No, I don't remember that bit. In fact, I know David Owen quite well. We live very near each other in London, and yes, but I don't remember him. I don't know. I don't think he necessarily. I don't know. I may be wrong. Push that beyond the comment in the Sunday Times. It would have been useful if he had. Maybe he did. In which case, good on him.
The quotation from one of the plaintiffs in the litigation, the department, it seemed to him that the department's position may be that it was better for plaintiffs to die off, as that would lower the sum for compensation. Did you pick up any indication of that in your time in the department, that that was an approach that was...
No, I didn't. You see, this is where there is a difference between journalism and what we had to deal with. Journalism is about drawing attention to things and not always doing so scrupulously. We don't know whether that person really existed to make those comments. But they didn't need to bother that with me, because I could make those comments to myself without, this business about they didn't care. We cared a lot, and there's all the evidence that comes in shows how much we cared. The question is, what was the best way to deal with it? The trust that was established to deal with people's individual needs was a starting point, not an end point. And that developed as these things went on. But what is certainly not the case, this government and other governments are not ready just to pay a great deal of money on the basis that it's a terrible thing what's happened. I would be, and I think that's really where the problem arises. What level of proof is needed to actually trigger that kind of response?
The same individual...
But we did end up, I think we ended up settling with these people for, was it 47 million, wasn't it?
42 million plus legal costs.
The 5 million for the lawyers, yes, we mustn't forget that.
We will come on to that a little later. But the other point made by that individual, and I'm afraid I cannot assist as to who that person was, but certainly the Sunday Times were in touch with a number of people who had haemophilia. This is a direct quote from somebody who had haemophilia.
So they say. Well, look, I know about newspapers, and so they say, bless them. But maybe some people are influenced by that. But I personally thought the facts were powerful enough without a lot of rhetoric from people who... I don't understand why if that person took that view, he couldn't, or she couldn't, be revealed as to who they were.
Well, they were revealed in the paper. It is a redaction that we have placed.
And we know that person actually existed.
I can't comment on that.
No, exactly.
But
anyway, look, it's, the real point you're making is that this was a hot potato which a sensible government would want to deal with, which was always my view.
The reference that is made there is to a failure to take ownership of a mistake. Did you think that what the Department of Health had done in respect of the infection of people with haemophilia was a mistake, or was it in your view, an accident?
No, I think I mean, what do I really think? I think that it was, personally, I would have been more sceptical about using American blood products bought on the open market in a society riddled with all manner of diseases occasioned by drug misuse and so on. But the product had to come from somewhere. And of course, what we didn't know, what they didn't know at that point, was that the product could, the infections that could be carried with the blood product had to be heat treated in order to get rid of them. The great advantage of being a journalist is you're never wrong, and you can be a counsel of perfection, and a Murdoch newspaper is never wrong, is it? But basically, where they get it wrong is by sort of imputing some sort of bad motivation to people who were really trying to do their best with the information as it came in. But you're making the point. I mean, I don't want to argue against you, because I always said to any colleague who would listen, let's get out of this. Let's do the right thing, because there is no happy issue out of these afflictions, either for the poor people who are afflicted or for anyone who tries to prevent them getting proper compensation. And that's when the hosts of the Valium dependents march in, and government suddenly takes fright, although it was ultimately settled, as we know.
Do you think that doing the right thing was just about coming to a financial settlement, or should there have been a reckoning about the government's actions as well?
Well, I mean, the point is, I mean, I certainly wouldn't be against that, and I'm sorry people have had to wait 30 years for this to happen. That's not my view of good government. But the point is, just because something awful happens doesn't mean it's somebody's fault. Personally, I would like to look very carefully at why these blood products were bought, bearing in mind it's hard to imagine a more dangerous element of society to buy blood products from than the sort of people who would be selling those blood products in America. But, you know, that no one could say on existing knowledge, as I understand it, way off my time, that this was the wrong thing to do. But, you know, our knowledge of medical science develops day by day, and just because someone or a group of people or a government didn't have that insight at that time doesn't mean that they're wrong, and doesn't mean, in my opinion, that they must automatically pay the uttermost amount of compensation, because you know, I really do think that no fault compensation sounds wonderful. You know, was it Professor Maitland of Cambridge University? I don't know if you had studied him when you were training to be a lawyer. He said, you know, to every human problem there is an answer, simple, obvious, and wrong.
Let's move away from that article. At paragraph 4.36 of your statement, you note that there was also, at the same time, a campaign that was being run by the Sunday Times, and Andrew Neil, the editor of the Sunday Times, wrote to MPs urging a quick settlement, and that led to briefing notes being prepared by the Department of Health for number 10, that's paragraph 29. I won't take you to those, but what I will take you to, also at, paragraph 4.35 of your statement of a reference for the document is DHSC 303849_078.
Yes.
Is a minute that is sent to Mr. Heppel from Mr. Davey in your private office, which refers back to that article that we have just looked at. And it says this: while returning from Qatar, Mr. Mellor handed me the attached article from the Sunday Times. Mr. Mellor has asked for advice as to whether there is any case for changing the basis for funding the Mcfarland Trust, if we can find any money for topping up. He would also like to know what criteria the trustees apply when making awards. I pause there to note that we've looked at the answer to that a little earlier. Point 2, quotes, he feels that the department will lose on this, whatever the outcome of the court case, and would like to see what more can be done. He thinks Secretary of State should also be made aware of the problem, and I am copying this to Mr. McEwen accordingly. He's in the Secretary of State's private office.
Yeah.
I will be grateful for advice by 24th of October, please. And that's from Mr. Davey. So this is you, first of all, asking for some fresh thinking on the litigation, and also involving the Secretary of State. Yeah.
Secretary of State would be a powerful ally, and you know you can't really do anything if your Secretary of State, as your Minister of State, doesn't back you up. But also, you know, I mean, it's always worrying when you think you thought something and then you look at the documents and you find you didn't, or you only clumsily expressed it. But I mean, I think even my worst enemy could not say that throughout all of the stuff you've looked at from me, I have expressed extreme scepticism about most of the ways in which, you know, other clever people were trying to say we could wriggle out of this.
Let me take you to another document that was provided to you after you... it was provided to you at the time of your statement, but not one that you referred to. There's no criticism for that in your statement. It is DHSC 306279_025. This is a minute from Mr. Dobson, dated the 16th of October 1989. I note that your previous minute was sent to Mr. Heppel. Sorry, just before we move on to this, a question I should have asked you about that previous minute. It seems that the initiative for that minute, the one of the 11th of October, came from you. You had read the article,
Yes,
you were concerned
I
about
did.
it, so you were prompting the action.
What else does one do on a flight back from Qatar than probably on an aircraft that doesn't allow drinking, but read the Sunday Times? It's a desperate measure, but it was useful in this instance.
And that led to some, as it maybe said, a proactive decision by you to seek the minutes rather than
because,
something...
there is no point in making the point that this is going to be very hard to handle. Then when somebody writes something that is very hard to handle, you don't give others the benefit of considering it, I always thought the government's position on this was untenable, and I don't think I was wrong about that.
If I can turn then to the document that's been brought up on the screen, apologies for leaping back there a second. This is, as I say, Mr. Dobson writing to a significant number of people, including Mr. Heppel, Mr. Hart, a senior civil servant who went on to become the
Or Dr.
permanent
Metters,
secretary.
yes.
Dr. Metters, or at least the private office of these individuals, people in the AIDS unit, people in different divisions of the Department of Health, Mr. Powell, a solicitor.
Yeah, this went all the way around, and it was intended to. This was not, for limited people. This was intended for a wide range of the top people in the department to become conscious of this, and that was the response. Yeah.
Let me just read through the document, because it's not one the inquiry's looked at before. What Mr. Dobson says is this: haemophiliacs and AIDS litigation. There are growing signs that ministers are becoming increasingly uneasy at the current advice from officials that, on balance, the government should resist the claim of HIV-infected haemophiliacs and, if necessary, fight it out in court. For instance, the Minister of State for Health has, on 2 occasions, asked for briefing on articles in the Sunday Times and, on the most recent occasion, has asked for advice as to whether there is any case for changing the basis for funding the Mcfarland Trust, if we can find any money for topping up. Minister of State for Health also, quotes, feels that the department will lose on this, whatever the outcome of the court case, and would like to see what more could be done. All this suggests that it would be timely to review where we are on the AIDS litigation front, to consider what options could be offered to ministers if they are minded to be more responsive to the haemophiliacs case, e.g. an out-of-court settlement which did not require HIV-infected sufferers to demonstrate financial need, and to consider how any such relaxation could be presented in the most favourable way. If we could fit in a meeting later this week, that would enable us to give some indication of the possibilities in response to the Minister of State for Health's latest request for advice. My people will be in touch to try and find a suitable time for a meeting. I've assumed that the AIDS unit do not need to be involved, but I will, of course, be delighted if they would like to be represented at the meeting. That would seem on its face to be an open request for those listed to start thinking about this. Is that fair?
Well, and to do something about it, yes. No fault. I understand all the general objections to no fault compensation, but I thought that the ingenuity, the collective ingenuity of those named in that, would be able to find a point of distinction that would allow proper compensation to be offered without, I can't emphasize this too much, falling into all manner of other traps in relation to causes that, while they believe themselves to be worthy ones, I'm not going to die in the last ditch for, diazepam folk, wrongly, I'm sure, but my view was that was a different level of problem to what happened with HIV-positive people.
I'm going to take you now to the document that was produced as a result of this. It was sent under a cover of minutes dated the 26th of October 1989, the day before that you left the department. We'll come to that covering minute in a second. But let's look at the briefing first.
Just so people, by the way, are not surprised about all this jumping around. At that point, Mrs. Thatcher was falling out with a number of her senior ministers, as a consequence of which my dear friend, the late Lord Waddington, was transferred to the Home Office as Home Secretary. And in the Home Office was a bastard child, a very complicated broadcasting bill, establishing all the things about satellite television and a whole lot of that, which I had worked on when I was last in the Home Office. And he told the Prime Minister that he wasn't going to handle that himself and that I should come back and deal with it, having apologized to me for forcing me to go back to a department I'd already had enough of. And that led to an unseemly row between Kenneth Clarke and Margaret Thatcher, where at one point Kenneth Clarke is standing in his bath, stark naked, at the people of Kennington looking in the ground floor while he's waving his phone around and shouting. Anyway, that did not work, so I was transferred back to the Home Office.
Did the I was going to ask you about this later, but as you've raised it, let's discuss it now. You were in post for a little over a year in the Department of Health. Was that long enough for you to be able to get a grip on these issues and to move policy forward?
But it's never long enough. You see, what you should have in a properly run government, where you wouldn't have people resigning in a huff and all the rest of it, people should be appointed as, you see, this derisory sort of about people being junior ministers or ministers of state or whatever. In a properly run department, everyone had their role and everyone had things that they had to get on top of, and it's almost impossible to get on top of things immediately. A bit like, you reading a complicated brief. However hard you try, it does take a bit of time to get a grip of it. And I very much regretted there were times when, through no fault of my own, I had to go back to the Home Office. And although I found the Department of Health by a fair distance the most difficult assignment, I was quite getting into it, and I was sad when I was sort of taken away. And I like to think, because sometimes it had, I don't think it actually impacted on this, but I remember I agreed with the hospice people that we would pay half of the costs of hospices. And no sooner was my back turned than the then ministers just removed that. So sometimes it does matter that you stay in the department a good long time, work out what needs to be done, and then stick around to do it.
Was there any process of handover where you could say to your successor, this is what I'm intending to do?
Not very readily. It would depend on the successor and whether the successor wanted assistance or not.
In this case, I think it was Virginia Bottomley who became Minister of State for Health.
Yes, dear Virginia. She's a good friend of mine too, though I still haven't forgiven her for what she did over the hospices, but never mind.
Did you have an opportunity to discuss the HIV litigation with her?
I don't think I did, you see. And that was because you get suddenly thrown into a new, or in my case, an old department, and a whole host of things. And, the Broadcasting Act was a complicated and difficult piece of litigation where one just had to devote a lot of time to it. Sad.
Just so that we have the political and historical context right, it was the resignation of Nigel Lawson in October 1989
that's right.
as Chancellor of the Exchequer that led to this reshuffle.
Right. Yes.
Let's turn back to the documents then, and DHSC 302536_079. Now, this was received, as I say, on the 26th of October.
Now, this is the one I haven't read. I mean, I'm sure it won't contain anything that would surprise me, but I haven't read this one.
Just so that you're at ease, the principal purpose of this is putting it on the record so that we can complete this part of the chronology. Because this is what you asked for.
Yes.
This is what was produced, but by the time it had been produced, you were no longer in post to consider it.
Yes.
If we can read through from the top of the document, it says HIV, sorry, if we could just go up again a second. The reference is ARTH 1910, which may suggest that Mr. Arthur was involved in drafting this. I'm afraid this is the latest copy that we could find. We couldn't find one which was formally marked as the final draft. HIV haemophilia litigation, 1 current policy, litigation, point 1. Following previous discussions with ministers, the Department and the other central defendants in this action, the Committee on the Safety of Medicines, the Licensing Authority and the Welsh Office, are presently acting on the policy that the plaintiff's claims should be put to the courts and that all allegations of negligence should be contested. Officials know from a meeting with representatives of the other defendants, the health authorities, that they are assuming the same stance. Facts are still being collected for counsel, but officials believe all the plaintiffs' allegations can be successfully countered. It is also known that the Haemophilia Society sought legal advice some time ago on whether actions for negligence might succeed. They were advised against pursuing such actions. The Minister of State for Health has seen Mr Wilson's submissions of the 18th of October 1989 on the question of whether the duty of care issue should be taken as a preliminary issue in the HIV and Valium litigation. He has commented that he does not think it would be to the government's advantage to do so in the HIV cases. Counsel has advised that he sees difficulty in raising it in one case and not the other. He has suggested a possible approach, and this is set out in a further submission coming forward separately on that issue. Minister May also wished to note that counsel for the health authorities has indicated he will wish to raise duty of care as a preliminary issue. Our counsel also wishes to take other preliminary points, for example, whether the government's alleged failure to take action to protect haemophiliacs against hepatitis is relevant to HIV litigation. The upshot might be, especially if the duty of care issue were, after further consideration, to be run in the HIV case, that so much of a plaintiff's case would be removed as to undermine the whole case. The Legal Aid Board might reach the view that the plaintiff's chances of success were so slim that the case should not be funded. Counsel has advised that there are better prospects of success for those small number of plaintiffs who were infected between heat-treated factor VIII being introduced and it being readily available in the UK. If the preliminary points did not succeed, the defence would contest allegations of negligence at the main hearings, probably in early 1991. We believe that we could present a robust defence given, 1, the uncertainties in scientific knowledge of the AIDS virus and its routes of transmission in the early 1980s, 2, the very considerable efforts made, once the nature of the threat became clear, to protect against it, e.g. screening of blood donors. This section on the Mcfarland Trust I read earlier, and so we can skip over that and go to page 4, please. Other options for the future. If ministers are minded to review our current stance, possible options for dealing with this litigation and or for increasing the financial help presently on offer to haemophiliacs are as follows. Option A, out-of-court settlement. The Haemophilia Society, MPs, the press, and a substantial body of opinion within the NHS favours an out-of-court settlement so that those suffering the effects of HIV infection can quickly be assured of financial security. If the case is lost in court, our counsel suggests awards would be £50,000 for a plaintiff with no dependents and £150,000 for those with a wife and family. We do not know how many haemophiliacs with HIV will pursue the action, but if all 1,200 do, the total cost could be in the region of 60 million to 180 million shared among the defendants. An out-of-court settlement, to foreclose any future legal action, might cost at least 2/3 of the total damages the court might award, i.e. 40 million to 120 million. If the department took its own initiative to settle out of court, it would have to meet the whole bill itself. Ministers may find it difficult to persuade Treasury to find money for an out-of-court settlement at this stage when counsel feels the plaintiffs will lose. It would, of course, spare the government what is likely to be a considerable sum in costs of the litigation, both directly on behalf of... we go over to the next page, that's a blank page on the photocopy. Both on behalf of the RHAs and indirectly through the Legal Aid Fund. The trial is likely to take 3 to 5 months and will involve at least 3 QCs, about 6 juniors, and all the necessary departmental, legal, medical and administrative support. Since the early 1980s, with the Oprin case still continuing, I pause there to note that that is a litigation concerning an anti-arthritis drug, the government, in its role as the licensing authority for medicines, has been involved in a number of court actions. So has the Committee on the Safety of Medicines. It has always denied liability and resisted any overtures to be involved in out-of-court settlements because of the implied admission of liability and the risk that it would encourage further litigation and public pressure for similar settlements out of court. There is already, in addition to HIV, potential major litigation involving benzodiazepines and the IUD copper 7. Whilst there may be unique features in the case of HIV, officials do not think that any out-of-court settlement in that issue could be effectively ring-fenced so as not to create a precedent. Any such settlement would need to involve the licensing authority and the CSM. It could not just include the Secretary of State in respect of his NHS responsibilities. It would accordingly be a precedent for similar out-of-court settlements of other claims against the licensing authority and CSM. It would also be likely to encourage further litigation against the authority, which would be damaging to the integrity of the licensing system. It could lead on to over-defensive licensing decisions and reluctance of academics to serve on CSM and other Section 4 advisory committees.
And CSM, people might not know, is the Committee for the Safety of Medicines. Right?
That's right, yes. On which the licensing authority is reliant. Even if, in principle, ministers were inclined towards an out-of-court settlement, there are some difficult questions of detail to be resolved, some of which might prove contentious. For instance, should the award be restricted to plaintiffs in the action or offered to all HIV-infected haemophiliacs? Should there be a standard amount or an award tailored to individual circumstances? For example, whether legal costs have already been incurred, whether full-blown AIDS had developed, number of dependents, etc. In the latter case, would the Department of Health itself determine the schedule of awards to be offered, or would they make a total sum available and invite the Haemophilia Society or the plaintiff's solicitors to allocate it? Option B, explicitly increase funding to the Mcfarland Trust. The Mcfarland Trust could be given additional funds, again on an ex gratia basis. Realistically, the trust deed would need to be amended to place minimal emphasis on means testing and perhaps to allow substantial help with loans for housing, etc. The additional amount would be a matter of judgment. At one extreme, an addition 5 million to £10 million would at least indicate that the government was sympathetic to the plight of haemophiliacs, but it would still leave compensation in the UK behind some other European countries, see Annex B. It would be unlikely to buy off the litigation and might even be counterproductive if it were regarded as too mean. At the other extreme, an injection sufficient to satisfy the plaintiff's financial aspirations would involve a substantial amount moving towards the likely range of costs for an out-of-court settlement. It is difficult to assess whether increasing the trust fund financially will meet the plaintiff's other motivations for the court action, viz. To establish official recognition that they have become infected with HIV as a result of contaminated blood products. Some might proceed with litigation in any event. Moreover, there are signs that the haemophiliacs are looking for a lump sum without having to submit to any needs test, however generously it is effected. Channeling more money through the Mcfarland Trust might not therefore dissuade many plaintiffs from the court action, even though it might reduce the now very extensive public sympathy for their cause. It is also possible that if haemophiliacs have received reasonable compensation, the legal aid fund would be unlikely to continue support and thus effectively reduce the likelihood of litigation continuing. Option C, ex gratia payment. An amount could be allocated on a no-fault compensation basis that would provide an ex gratia payment to haemophiliacs without either admitting liability or involving the Mcfarland Trust. The advantage of this option is that A, by removing the stigma of means testing, it may make it easier for plaintiffs to accept it as an adequate recompense for their injury. Some might wish to pursue their claim in order to pin the blame on the government, but if only a few persisted in this way, the action would collapse. 2, it would be evidently a direct payment from government rather than from some anonymous special fund. Costs, for a scheme likely to prove acceptable, would be similar to those for option A. Ministers have opposed no-fault compensation schemes since the Pearson Commission reported in 1978, largely because of the knock-on effects. We would find it difficult to find convincing arguments for why haemophiliacs were thought a uniquely deserving group. Option D, Commission of Inquiry. An option mooted by an NHS Haemophilia Centre director attached to the Haemophilia Society was that a Commission of Inquiry might be established. This could either assess the government's record over the relevant period or consider the case for an ex gratia payment along the lines of option C, or both. Officials believe this would need to be linked to an interim ex gratia reward, perhaps to the Mcfarland Trust, to overcome the recurrent argument by the plaintiffs that however the issue is resolved, it should be with all speed. The eventual cost of this option might be similar to that of option A or C. The advantage is that it might be slightly easier to avoid knock-on effects, since we could always refer back to the Commission of Inquiry, C of E, judgment that haemophiliacs were a particularly deserving group, but such a C of E, Commission of Inquiry, would itself be a precedent. Option E, publicise the government's position. As a matter of general policy, the department has so far maintained a low profile in the face of critical press and public rehearsals of the HIV litigation. This could be taken to imply inertia or lack of concern. As a final option, on its own or in combination with one or other options A and D, the government could take steps within the constraints imposed now that the matter is before the court to set the record straight. The allegations of misinformation contained in the Sunday Times campaign have already attracted Mr. Justice Ognall's attention. He has been provided by our counsel with material relating to the Opera case and Mr. Justice Hurst's response to help in deciding whether a court order might be appropriate. If a response would not itself be held in contempt, a parallel history of the facts could form the basis of a departmental press release. Distorted comparisons with compensation available in other countries, often more limited than the UK's, could be challenged. Annex B to this submission rehearses the possible response to the main points mentioned in the Sunday Times campaign. Financing. It is highly unlikely that Treasury would agree to providing any substantial additional funding, particularly as the advice from Council is that we would win the case in court. The Department's own resources are very tight. There is virtually no flexibility this year and already strong pressure on next year's resources. These mean that an out-of-court settlement is not likely to be a runner and that it will be hard to fund any lesser concessions. Summary. In light of the difficulties with option A, C and D, our advice remains that the Department should publicise the extra flexibility we have offered to the Mcfarland Trust, but continue to strongly defend the court action. Attempts could also be made on the publicity front to counter the critical reporting so far. Ministers may wish to consider 1, whether they would wish any of the alternative options to be worked up in more detail, 2, whether they would wish us to begin soundings with Treasury on the possibility of increasing, by whatever means, the funding available to HIV-infected haemophiliacs. So that is the document that was produced. I'm very briefly, I'm conscious of the time, so I've got about 50...
Well, you've got to ask questions, having you laid the groundwork.
I will do so. Just before I do just quickly want to show one of the parts of the appendices, which is the international comparators, DHSC 302536_081. It's page 2 of this document. And G. This is a briefing responding to allegations made in the Sunday Times campaign.
It came in tabular form. It might be easier for people to read. I'm sure I've seen one tabulated.
I'm not sure I've seen a there is one later, but that's for a year later.
That's later, right.
So this is the document that was provided with that briefing. But we will come to that later. There have been no court settlements yet, and other circumstances vary greatly. I pause there to note the other circumstances would include, for example, the baseline of social services payments, social security payments made in each country. Returning to the document, in West Germany, companies are liable by law, and settlements of £15,000 to £160,000, average £27,000, have been reached between pharmaceutical companies, insurers, and claimants. 1 or 2 cases are pending against the federal government, which does not accept liability. In France, a solidarity fund provides an average of £10,000 income related and spread over several years. Only those with AIDS benefit. No agreement reached for those who are HIV positive. In Denmark, ex gratia payments of £8,000 to £10,000 were recently increased to £20,000 to £25,000. Norway have provided ex gratia payments of about £2,000. A court case against the government is nearing completion in Canada, but no actual details are yet known. For comparison, the UK ex gratia payment through the Mcfarland Trust is currently equivalent to about £8,000 per head and is available to all HIV-infected haemophiliacs, not just those with AIDS. I won't take you to the covering minute, which was from Mr. Dobson, but for the record, it's DHSC 302536_078. That echoes the advice that was provided at the end of the briefing, which refers to the difficulties there may be with a out-of-court settlement. He says in that advice, and I'll just read this section, our advice therefore remains that ministers should continue with the litigation and should not signal any readiness to provide additional funding beyond the steps already in hand to allow greater flexibility to the trust and a veiled promise to consider topping up when it is needed. Bringing all of that together, 4 options were presented in the paper. An out-of-court settlement, increasing funds to the Mcfarland Trust.
Well, 5 options, I think. The 5th was publicising the government's position.
Yes,
you probably regarded that as a council of imperfection, didn't you?
I think that is intended as something that could be done whichever of the other 4 options could be adopted. It is an additional option, not necessarily something just to be done on its own, unless a decision were taken just to reject each of the other 4 options. But the 4 options for positive action, as it were, are the out-of-court settlement, increasing funds to the Mcfarland Trust, an ex gratia payment, and a commission of inquiry, what we might now call a public inquiry. Would you agree that those 4 options available in October 1989 and identified in 1989 were more or less the same ones that were available in December 1990 when you came to reconsider this matter as Chief Secretary?
I'm not able to comment in detail on that, but that was when we sorted it out, wasn't it? Yes, and I think at a payment of 42 million plus 5 million.
Yes.
Yeah, no, I mean, what can I say? It never sounds enough, does it? But at least it was a major step forward. But yes, there were no other options, I don't think.
The way that it is sorted out in the end is a combination, as it were, of options A, B, and C.
Yeah, but there's nothing wrong with picking and mixing. What one wanted to do was to get a serious amount of compensation available and beat off all the arguments, either for doing nothing, all the arguments for good publicity, which was just a joke, or, you know, all the arguments that meant, well, because lots of other people will come in and try and take the benefit of it, then we don't do anything, we just stick where we are. So, yeah, I mean, I would regard that as, success, really.
But it is. But
it's not perfect, as we know.
A success, as you put it, which comes in December 1990, when all of the options have been identified in November 1989.
Yes, but dare I say, one of the principal... Look, this sounds self-serving. Will you allow me to be self-serving? One of the principal agents for change was busy messing about with the broadcasting bill for that whole period. I only became Chief Secretary of the Treasury in the autumn of 1990, I think.
Are you, of course... You wouldn't have had time to consider this submission because you left the following day.
I only read it for the first time just now because, you know, at the end of the day, when you leave a department, you've got to get on with the next thing. And, you know, the Broadcasting Act, major change to the broadcasting environment. And it then depends on whether people are interventionists or not. And they had a lot of trouble at the Department of Health, you know, with all the reforms of the health service and all the rest of it. And sometimes people can be perfectly satisfactory in the role, say, that I had, whilst being more passive.
These observations about why it took a further year, are these observations that you make now reflecting generally on the government, or were they matters that you had in mind at the time?
No, I mean, you know, when you're in government, you know, you just do what is on the desk in front of you and do the best you can. And you know, you don't have time to worry about what you didn't do the last time. But I suppose, if I'm honest with you, I'm quite disappointed now. I read that minute that nothing more was done more quickly. But there you are.
Looking at that minute, and as you say, you've seen it for the first time now, are you satisfied that the Department of Health officials were providing ministers with appropriate options from which they could choose?
Well, I don't know. I can't think of another one, but I'm only sitting here, you know, having looked at it for 10 minutes. But I mean, I don't know if other people are suggesting other ones, but other ones that are practical, bearing in mind that what you have to do is just to, you know, you cannot take down all the fencing around substantial sums of money. And they've tried to do that with what they've been doing over over the recent pandemic, and the fraud appears to be on a catastrophic level.
So that is where I intend to leave the HIV litigation from your time in the Department of Health. We'll pick it up after the break as your time as Chief Secretary. I would merely direct everybody to paragraphs 4.37 to paragraph 4.44 of your written statement, which deals with the duty of care issue. I don't intend to take you to any of those documents, but people will be able to see there the view that you took on that point.
Yes, so we come back to Mr. Mellor's time at the Treasury at 2:15. 2:15.